Every single time I turn on the news, I'm seeing the same thing. And you know what? As an employment attorney, I can tell you it's beyond sad. It's disappointing. What's really going on with the employment relationship? Because every time I turn on the news, do you know what I'm seeing? You see it too. I keep seeing reports of mass layoffs. Welcome to the employment space. This channel is designed to provide you a 360-degree view of the employment relationship, not one side, not the other side, but all sides of the employment relationship. And it's directly from an employment attorney. This channel is for employers, employees, independent contractors, vendors, employment attorneys, and HR professionals. Today, we're going to get into what the employment relationship probably needs the most, and that is about severance agreements. Let's clock in. Forgot to ask you, please like, share, subscribe, and comment. I promise I will respond. And also let me know which of these keys that I'm about to list are you hearing for the first time. Okay, back to the content. Let's first get into like 3 general rules about severance agreements before we hop into the 10 important things about severance agreements, okay? So I'll give you the 3 general things that I like to remind the employment relationship about. And that is, the first general rule would be that, a severance agreement is a contract. It's no different than the type of contract you enter into. I'm not gonna say it's no different, but it's in terms of it being that type of tool. It's seen as a contract, right? Just as we see a contract when it comes to signing up for a gym membership or entering into some sort of like residential lease or something like that. Or if you purchase a new phone device and they say sign here for your contract. A severance agreement is seen as the same, seems like it's a contractual agreement. It is a contractual tool, okay? The second thing is that severance agreements are only provided to employees, okay? So if you're an employer and you've been properly classifying your workers into employees, if that's the proper classification, then in general, when it comes to severance agreements, they're only issued from an employer to an individual properly classified as an employee. And if you want to talk about or learn about classifications as an employer, then check out my post on the 5 things employers should know about the Fair Labor Standards Act. We talk about classification there. The third general rule about severance agreements is that it's not a legal requirement. So no employer in the United States is legally required on the federal level or on the state level to pay a departing employee severance pay. Okay? All right, let's get into the 10 things the employment relationship should know about severance agreements. Number 1, a severance agreement is going to be a contract that carries key terms and actually very much so standard terms. So when you go through a severance agreement, me being a former employment litigator and employment counsel, I've always seen severance agreements that carry some key terms. It'll have your name, it'll have an employee's name, it may have your date of employment, the position you've held. It may have some other key terms about you. So make sure as an employer that the key terms are correct, and as an employee, make sure that the terms about you that are appearing in the agreement are correct. And again, there's some standard terms. You may not know that as an employee, but as employment counsel, I've seen some of these terms over and over and over again. That's why it's important for you to also consult an attorney. But overall, number 1 is that severance agreements are known to carry some key terms about the employee. Number 2, for the employer, make sure that any obligations that are supposed to really benefit you're a part of the negotiation or in the agreement. And for the employee, make sure that you review the agreement and understand any obligations that you're responsible for potentially carrying out after you sign the agreement. Okay? Number 3, severance payments that are included, that language is included in the severance agreement. Whatever severance payments are announced in that contract, it's not a gift. Severance payments are definitely going to be subject to, for the most part, should be subject to tax withholdings, unless as an employee you have some different like W-4 elections, but in general, in the severance agreement, the severance pay is going to be subject to tax withholdings. This money, these payments should not be considered a gift. Number 4, make sure that for the employer, make sure that your language is clear about any PTO, language about bonus, COBRA, things of that sort, and the employee the same thing. So as going through I can't tell you whether to sign the agreement. I can't say that as an employer that your agreement is overall compliant and good, but I'm just kind of sharing what is the typical language typical information in the severance agreement. So are you supposed to be including bonus information or information about COBRA or PTO that's supposed to be paid out to the departing employee? Number 5 is severance pay is typically paid out to the departing employee based on the means that was last filed or on file with the employer. So if you had direct deposit with a specific bank, then the severance pay is going to be paid via those same means. So as an employee, if you leave the company and you change your bank information or you prefer it to be sent to you by some other means, it is your obligation to make sure that you tell the company about that, or else you're going to receive severance pay as if it's a paycheck, probably via direct deposit, using the same means that was used by the company when you were employed. Number 6. Now this is a little bit of a robust area. Number 6 is about the consideration and revocation period or time frame that an employee has, a departing employee has, that should be included somewhere in the agreement. And the employer, you're responsible for making sure that the consideration and revocation periods are correct. And for the employee, it's your responsibility to know when you're supposed to get the agreement signed and back to the employer based on what the employer has required as the contact person or means for the organization to receive a signed agreement. Now, let me just say this. Now, if you are at least 40 years of age and older, then you should have a certain amount of time. It's called a consideration period. You should have a certain amount of time to consider the agreement, and then a certain amount of time after signing the agreement to revoke your signature. But understand that, when it comes to the consideration period, it's typically a certain amount of time. It's typically about 21 days. And understand that if you sign the agreement as soon as you get it, or you sign the agreement less than 21 days, and you submit it back to the organization based on how you were supposed to, then you end up stopping your 21-day period, and now you begin or you trigger your 7-day revocation period. Okay, so just kind of want to make sure that that's clear. It's not that you have the 21-day consideration period, and then once you sign it and you send it into the organization, that the balance of the 21-day consideration period is still running. No, when you sign it, you stop the 21 days, and now the company is waiting for 7 days, giving you the 7 days to see if you're changing your mind to revoke. Okay, to revoke your signature. Okay. If you are under 40 years of age, you typically will not get the same consideration period as would a departing employee who's at least 40, unless the company just wants to do that as standard, but typically you won't get the same amount of consideration period, and you may or may not get a revocation period. So make sure that if you're under 40 years of age and you're a departing employee, that you read and understand for both groups, you understand, it's your responsibility to understand how much time you get to consider, if you get any, how much time you get to revoke your signature after you sign and submit it, okay, back to the company, before the company has any obligation to pay you, okay? So that's very, very key, because if you have a 21-day consideration period and you sign it and you don't submit it back to the company, then the company is probably expecting that your 21-day consideration period is still going. You have to sign it and send it in to stop the 21-day consideration period, and then the revocation period at that point is running. Okay, so that's number 6. Number 7 is how severance pay is typically processed. A company will have an internal payroll system. That same team will process will get the agreement and process the pay, the severance pay. Unless the company has like a third-party payroll system, then that information will be sent to the third-party payroll system, and that's who will be sending out and issuing your severance payments based on the severance agreement. Number 8. Typically, severance agreements and the policy of severance pay from an employer is not willy-nilly. It's typically paid based on some sort of practice or some sort of policy. Number 9 is specifically for the departing employees. You may ask, do I have to, once you're signing the severance agreement, does the severance agreement create any obligation to you as a departing employee to tell new employers about your severance agreement? And the answer is no. And number 10, if you don't sign, you don't get paid. That's simple. So we finished the 10 things that the employment relationship should be reminded about regarding severance agreements. I hope this was helpful. And again, I'm trying to provide you very selectively a 360-degree view of the employment relationship. Also, don't forget to like, share, subscribe, comment, and share. I appreciate your comments, and I definitely will be reading them and responding. And I hope you enjoy the rest of your week. And thanks for watching. Take care.